All right, we are live with Duane from DSD, Eric Johnson from Utah Family Law TV, Wendy Hernandez from Command the Courtroom. I'm Alex from The Proper Person. I wanted to mention that we are going to use the format from another YouTube channel where they have 4 speakers simultaneously, and one of the things that I noticed is that it seems to work really well because the person who is speaking is the one who decides who to pass it off to. And I also noticed that they usually don't do it live. So guys, this is new for us. We're trying. I think that most of my channel knows who I am. For the rest of the channels, I represented myself for 8 years in a high conflict child custody case. And let's pass this off to Wendy.
Hey everybody, Wendy with Command the Courtroom, and I don't know how long my channel's been going, but I'm an Arizona family law practicing for 25 years, and I love sharing my knowledge who are representing themselves in the family law process, and also love passing on information to people who have experience. So I'll pass it off to Mr. Eric.
I do not make a habit of participating in these kinds of programs looking at my family and I at this very moment, and we are at Law Mahad. I am literally sitting right now, but I'm glad I am in Utah, and I run Family Law TV, and I've been 27 years myself.
And that looks like you're up, Duane.
Hey everybody, I am Duane from DSD, Dad's Thriving Divorce. I've been running my channel for a little over, coming up on 5 years, a little over 4 years. And my main focus is helping people who are going through a high conflict, toxic divorce to deal with the emotional side of it. I'm not a therapist. It's basically more peer support to see somebody who has gone through this, who has made it to the other side, and can hopefully help you get through your situation as well.
All right, so there was some echo apparently picked up, but I went ahead and fixed that up, just cleaned it up, guys. Let us know in the chat boxes.
Oh, cool.
Let any of you, your YouTubers, whichever audience you're in. It looks like my audience is saying that the echo was fixed, so that's awesome. We don't have a topic, guys. We were just going to wing it, and I'm going to go ahead and give Wendy the opportunity to start us off. If she doesn't have one, I have a few ideas. There's some legislation in Nevada with regards to the judiciary and stuff like that. But Wendy, go ahead and start us off.
Well, I guess I don't know how much any of you have dealt with people facing supervised visitation or supervised parenting time. But this is an issue that's come up recently in a couple of cases that I have. And, I'm interested in what the other speakers, Alex's, Duane's, and Eric's perspectives are on the qualifications of a supervisor, how important a supervisor is in supervising parenting time, what sort of things to look for at a supervisor. Certainly supervisors come up when there are cases and there's been past domestic abuse or some sort of danger that's been caused to the children, and other circumstances where I think that the judge might think supervision is appropriate. But Eric, I'd love to hear your perspective on supervision in Utah.
I think supervision is generally a bad idea. I think, and I am known in the profession as something of an iconoclast. I don't mean to be, but I just, there's a lot of things that we do that are kind of conventional here in Utah, and I would assume in other jurisdictions as well, that I just don't see the purpose of, and it's not for lack of trying. I just don't find them to be terribly good. So when it comes to supervision, sure, there are situations where you might have someone who is clearly a danger to him or herself or to the children and could benefit by making sure the children have contact with that parent, but in a supervised setting in case there's any danger to that person or to the children, whether that be physical or some kind of emotional harm. But generally speaking, I find that a lot of this is trumped up to get a supervisor for the purpose of stigmatizing the supervised or the to-be supervised parent, whether that be the dad or the mom. Now, let's face it, most of the time people are seeking supervision for fathers, claiming that they are violent, claiming that they are alienating, claiming that they are substance abusers. But there are also moms in the exact same situations as well. And I just find that supervision usually is a bad idea. And then once it's imposed, it's very hard to reduce it. So in Utah, you have to have certain standards that are met. We have a statute that requires that, which I think is good, saying that if supervision is imposed, there has to be a plan for getting that person off supervision if they meet the criteria or the plan that has been set forth by the court. But what happens is you meet the criteria, come back to court asking for a review, and then you're either hit with being accused of not meeting the criteria or claiming that new problems have arisen that require a new set of criteria and another set of supervision. So those are my thoughts. I just find lots of things. People abuse the system a lot in family.
What do you think, Duane?
Oh, I agree with what Eric is saying. I mean, but I think the difference, or the thing I would add on to that, is if you find yourself in that scenario where you've been forced to get supervised visitation, you have to go through the process. There are people who will turn around and say, I'm not going to do it, I refuse to do it, and then it's basically like you checkmate yourself. So if you get in that situation, you need to calm yourself down. You need to find out what the criteria that Eric was talking about, and make sure that you treat that like the most important job interview that you've ever had. Show up and just demonstrate that you're not what they're trying to say. The problem is if you get angry, you get upset, you take the bait, like I often say, then you can find yourself in a scenario where when you do end up back in court, they're going to say, well, yes, but now, like Eric was talking about, now there's these other situations that that are new problems, and we need to have those addressed. Bottom line is I feel that this is used as a tactic to limit your time with your kid, to try to give the other person a tactical advantage in court. Most of the time, I mean, granted, there are some times where there's some serious issues and this needs to happen, but I think a lot of times it's abused, and it's used to basically try to break the person who's being targeted from it. And like Eric said, I have on my channel, I have moms who are currently in this mode right now. I mean, I have dads who are going through that, but I also have moms who are currently going through supervised visitation, jumping through those flaming hoops to get to the point where they can have uninhibited access to their kids.
So I can't believe we're doing this, guys, but we're streaming to all these channels simultaneously, and it's working, and my comments are blowing up.
Yay.
So before I go
awesome.
to the next topic, I was just going to say, HC9 thinks it's hilarious that Eric's in the jacuzzi. Shay says that she's actually subscribed to all of our channels, and we have a possible.
I'm going to move from the jacuzzi right now, by the way. So I'm going to mute my camera for a second, and then I'll be right back. But I'll stay on with the audio.
I think this is awesome. It looks like this might be a topic for. We got a viewer on my end. His name is Tim McMichael. He says that he was watching a case on YouTube, and that both parents lost custody to the dad's mother. And I guess Wendy can go ahead and go into, I don't know if you covered your prior topic on supervised visits enough and you want to cover that a little bit more, or if you want to go into this idea of, I guess they call it third-party custody or non-parent custody.
Okay, yeah, so I'll go into that. But first I want to say that I agree with your comments, Duane, 100%. You know, whether supervision is warranted or not, whether something like drug testing is warranted or not, if it's ordered, I agree. Like, you know, the people have to go through it because the judge is going to have to be satisfied. And if the judge has made the order, then what choice do you have? You don't have a choice, in my opinion. Yeah. So, you know, and there are a lot of cases where it's not warranted. There are many cases in my experience where it is warranted. Yeah. But, anyways, going on to third-party custody. So if I understand correctly, Alex, the person who typed into the chat said that both the mom and the dad lost custody to a grandparent. Is that what you're saying?
And that is a thing in Nevada. Go ahead, though.
It is a thing here in Arizona, too. And there's certain language in the statute around when a third party can get custody of a child that's not their biological child. And if I remember right, the language is that it would be significantly detrimental for the child to remain in the care of a parent. It's a pretty high threshold to meet to to prove that it would be significantly detrimental. It's more than just, the child would be better off with the grandparents. You actually have to show that it would be harmful to the child in some way to stay with one parent or the other. And, in cases where I've seen that this happens, we're talking about one or both parents having serious drug issues, being imprisoned, one parent being absent from the children's lives for a long time, and the other parent just not being fit for whatever reason. So it's a high threshold to meet. It's very possible. I've had aunts and uncles and grandparents and step-parents get third-party custody of children. And at least in Arizona, it's not possible for a third party to share joint decision making with a parent. It's kind of like an all or nothing thing. Either the third party gets sole decision making or they get nothing at all.
Yeah.
So that's what I have to say about that. So Eric, I don't know if
he's
Eric's
not
on
he's
right
not
now.
back yet, but this is a good opportunity for you. One of your viewers, Tenacious Warrior, popped into my chat, and she says you're not streaming yet. You might just have to click that button again. Don't worry, I'll get you the raw footage if you wanted to publish it after the fact. So you're still being seen
weird.
on Duane's channel and my channel, but your channel, that button might need to be clicked in the upper right hand corner.
It says end stream.
Oh,
That's
so
odd.
maybe she's just confused. If you're streaming.
Well, hold on. I'm going to see if I can pull up.
Yeah, if you're streaming, Wendy, and you're seeing chat, if you're seeing stuff pop into your chat, then you should be fine.
I don't see anything popping into my chat, which I find odd, but I press the live button and it says live, and it has 11 minutes and 50 seconds, and then it says end stream in the upper right hand.
Did you put it as unlisted or?
Oh, she might have done that. You might have.
Because I don't see. You're not you're not on your homepage. You are not showing.
That's not cool.
You might have
Video.
accidentally put private or unlisted. It's possible.
Oh, darn it.
It's fine because I'll still send it to you after we're done. But
darn it.
so let's see here. Georgia, according to Omar, Georgia just passed a bill that eliminated the child being able to choose which. Oh, that's a good one that I might take. That eliminated the child being able to choose which parent he or she wants to live with at age 14. Oh, so they're just saying now it's whatever age, basically. I don't know about you guys, but Duane, I guess we'll go to you while Wendy's trying to check her.
Well, now people are popping
so you
into
fixed
chat.
it. Whatever you did, you fixed it.
I have no idea what I did. I just said a
hit
little
refresh on that.
All
prayer.
of a sudden,
Something
people are in your chat, so you know it's working.
I don't know what's going on. Okay, that's weird.
Maybe you did member only or something. Because I still don't see. Do you see? Hey, Alex, do you see her stream?
Check really quick.
Because I'm on your page right now, and I still don't see a live.
Oh yeah, Duane, yours for sure.
Tenacious Warrior says that. Oh, they're a mod for you. Says there's no video.
For me?
Duane? But I don't know. The part of the problem is there's going to be like a 30-second delay for when we try something before people see it.
That's.
Oh yeah, so. People are saying Wendy's live.
I would just trust that you're definitely live and that she might be having technical, or maybe even I do for whatever reason. But if you've got people chatting, then I wouldn't worry about it. If you weren't live, you wouldn't have anything in your chat box. So.
Well, since we're at this point, I wanted to just bring it because I had a person who had a question for Wendy, and it said, it was from Tiffany to Wendy. It says, how often is it used as a form of defense, as in victim asked for it in self-defense? And I think maybe what Tiffany is asking is like, Wendy, you had said that you've had times where you have asked for supervised visitation because there's a reason. So how often do you think that's the legit reason why it's being used? Do you think it's most of the time, or?
Well, so I will tell you that, and I tell my clients when I don't think it is a legitimate request, and I try to dissuade them from doing it. So it's rare that I make a request for supervised visitation. And so I don't use it that often. I would say in probably 1 out of 10 cases, I make this request. So there are very rare circumstances under which I believe it is a legitimate request. And, it's my position that there should be some sort of documented reasons as to why you're making the request, not just some airy-fairy theories, police reports, pictures, drug issues, something. I want something.
I agree with you. What I would say, and this is what I tell my folks a lot, is when this whole thing starts, be incredibly careful of what I call it not taking the bait. Because if you allow the stress and the anxiety, well, let me just put a scenario. So like if you were my ex's attorney and she came in with you and said that he's getting really angry with this whole divorce thing. He doesn't want it. The other day he threw something against the wall.
Yeah.
He's screaming at the kids. He's swearing at the kids. Then you start adding in, and he owns guns and he's, this, that, and the other. I don't think it would take much for you to say on the error on the side of caution, saying, okay, well, if that's true, then okay, yes, we should just at least temporarily to make sure that he calms down and doesn't do anything crazy. I guess I kind of tried to answer your own question, or answer the question, but how would you take it in that scenario?
Well, that's a toughie. And just because we ask, I may ask for it. I suppose if my client made it sound bad enough, and okay. I'm relying on my clients to be honest and truthful with me, which we all know doesn't always happen.
Right.
But I do have faith in our system. Does it work perfectly? No. Do sometimes bad decisions get made? Yes. But if my client's asking for something like supervised visits, chances are the other side's not going to agree. So chances are the judge is going to make that decision, right? And so I kind of trust that judge is going to make a decision that the judge thinks is best for the kids. I don't always agree with it, but we kind of got to go with it. Go ahead.
No, I was just going to add on to it. I remember hearing of a case early in my situation. So this is before I started the channel. So this is more of a in real life scenario.
Yeah.
And it was, divorce, high conflict is starting. And the catalyst that was basically got the guy in trouble is at a soccer match. He went to go talk to his soon-to-be ex.
Yeah.
And anyway, sorry, I just got a notification. Anyway, so
that's okay.
And what had happened is he went to talk to her, and the conversation got heated.
Yeah.
And he unfortunately, basically kind of blocked her access to leave, like kind of blocked her into a car.
Yeah.
Probably not even thinking about it, right? I mean, I think it'd be so easy to get caught up in that emotion and have that conversation. The next thing, restraining order, can't see the kids for the normal. I mean, the normal for everybody. I mean, anybody watching this, the worst time, in my opinion, the worst time is like October, November, right before the holidays. Inevitably something happens and you don't get to see your kids for the entire holiday thing. So you're sitting there, you've been basically forced to not see it. And part of the time it's because you made a mistake.
Yeah.
You let your emotions get away with you. You did something that may have been within character or completely out of character. And the person has basically set you up. And now they're able to give their attorney, they're able to walk into Wendy's office and say, look, here's the video of what happened. And you see this person losing their freaking mind going, holy crap,
Yeah.
And I mean, there's a lot of scenarios where that happens. And I would imagine if my ex was your client, you're going to err on the side of caution because you're not going to go, nah, you're just blowing it out of proportion.
Yeah.
I'm sure your ex is a good guy. And the next thing you know, you got the police telling you that your client's been hurt or worse.
Right.
It's changed so much
Yeah.
in Nevada.
Well,
it's changed a lot. In 2008, it was used all the time, and it was mainly women versus men. Women would use supervised visits against men, and it was mainly what you described, Duane, where you just kind of have to go through it for a while, and it would go away, like it did in my case. If you just followed all the rules for 6 or 8 or 9 months, magically the supervised visits would go away and everything would be fine. But now, it's not like that anymore. Now, it's like what Wendy said. Now, if you ask for it, you look bad. You really have to be careful. Asking, it's completely different than what it was back when I was.
Well, I wanted to bring up 2 things on that, and I would say that what you had mentioned, Alex, and I mean, I know we even talked about that in our interview, 3 years ago, and I've seen that with my own across the planet. I've seen people in America, in Canada, in Australia, in Ireland, all over the world who get caught up in these trumped up charges. It may take a year, but then it finally gets exposed, or basically knocked down. I think a big thing that's happened is the Me Too movement and the false allegations that high-profile people have done has really hurt these effective lies, because people are like, oh, wait a minute. You mean this stuff really, people really do lie about this? And I think that's hurting the people who have really had a problem. And I also think at the same time, it's helping people who are attempting, or helping people who are victims of the system where it's being used, because now it's like, okay, well, you're saying that, prove it. Why, okay, where is the evidence that shows that this is really an issue and you're not just blowing things out of proportion? Mm-hmm. Right?
We have some great comments. Christine says, my 3 favorites. Highway 419 says, wow, such a powerful panel of people. Those are his words verbatim. And we got a good possible comment here from Wise Guy. I wanted to give you some good news, Wendy. Even though Tenacious Warrior has been having issues, one of my viewers went just to make extra sure, and she went to your channel and she got into the video just fine. So that's great. This particular, Duane, you just made me remember something. We had a case. It was 8 or 9 months ago, relatively recently, I guess for law that's recent. We had a case where a lady accused 4 dentists of raping her, and it went to trial, and they found a video that from the hotel that proved it was totally false. The judge was livid. It was in the papers. It was like it was a bald-faced lie against 4 dentists. I still remember reading that article. It stunned me, because usually you think maybe it's just they just kind of got confused, or they don't agree, or things were, to think that somebody would not accuse 1 but 4 dentists who I guess were visiting Vegas. They were in a hotel room, and she accused all 4 of them, and it went to
At the same time? All 4 of them did something? Oh, wow.
I don't know why. Wow. I got hit.
Well, but so the sad part is you said it went to trial,
I need to read that article again. They were definitely charged. There were definitely proceedings. There were definitely hearings. But now I'm hesitant to say that it went all the way to a verdict. It may have not. Well, they reviewed the video, so I don't know how. I guess maybe the attorneys reviewed the video before. I don't know. I don't remember that part. But if you Google it, you will find it. So go ahead, Wendy. You have something.
This is the thing about the system, and this is one of the risks. It's a calculated risk that people have to make the decision to make about one, presenting allegations, true or not true, because of course, if one of my clients is going to make an allegation that, say father, committed an act of domestic violence, father's going to say, well, it's not true. Of course, I didn't do this. So then my client is faced with going into court and the judge thinking that she's lying and then being penalized. But it's always a risk going into the courtroom, because no 2 judges are alike. No 2 judges have.
Hello.
Happen, so you could have crap evidence and have the trier of fact believe you. You could have the best evidence ever and the trier of fact doesn't believe you. So it's always a risk. And what I say to my clients is you have to always evaluate the worst case scenarios and then make the decision from there. Like, I support my clients. If they want to go to court and I think it's a crappy case, I'll do it. I'll do the best job I can. But they have to be notified of the risks and understand that it could hurt them, because if a court finds that somebody interfered or tried to interfere with a parent's time or custody, that goes against them. That weighs against them.
We got Eric back, guys. Just so you know, I'm gonna go ahead and it looks like he's on his computer, so I don't know. Go ahead and elaborate on that, Duane. I'm gonna get his video back up.
I think, I was looking at some comments. It's some on my chat where some people are talking about, that they're in supervised visitation. They're talking about the cost of it.
Yeah.
And typically it's a prolonged thing, right? I mean, you're typically not going to get supervised visitation. You're not going to do a month and then it get resolved. You're talking about the long haul. and they make it as hard and difficult as possible. And I know maybe I'm diverting a little bit off of what you were saying, Wendy, but I think the importance is that it's incredibly important that you keep yourself as calm as possible, meditate, get a therapist. I mean, do whatever you need to do so that you can ride this storm and get to the other side. Because the sad reality is if you get caught up in this situation and you continue to make mistakes, or you make more mistakes, you're just digging a bigger hole you're going to have to crawl out of.
What do you mean by costs? Because in what way does it cost more? Are you talking about like when they send you to like a facility?
No, most people when you go to, I mean, unless you're lucky and you get to pick who you're, you get to pick Aunt May as your supervisor, you're having to hire a social worker or a CPS worker who on their after hours work, they do this, and you're paying $50, $60, $100 an hour. So, I mean, and if you're in a situation to where you don't have custody, right? I mean, so now your child support in most places, they key it into any place where it's guideline support, they key it into the calculator, and now, it's like, oh, okay, Mr. Smith or Mr. Duane, I'll use me as an example. You have 0% custody. That means you're paying, $4,000 a month, which is probably 60% or 70% of your take-home pay, and they don't care about you being able to pay your rent, you being able to buy food, and they absolutely don't care if you being able to pay an extra $400 or $500 or $800 a month just so you can see your kids for one weekend a month.
Could I chime in there?
Yeah, absolutely.
Because I agree. What's interesting is that when you try to say, okay, look, I can have Aunt May or my trusted neighbor or someone that we both know supervise who isn't a mental health professional, as if you need a mental health professional to watch you play in the park tossing a Frisbee around. I can see where therapeutic supervision may be necessary, but it's not necessary in nearly as many situations as people would claim. But one thing I've offered to do is say, look, let's bring a GoPro camera, strapped to somebody's chest, or just a phone turned around in somebody's breast pocket. Let's have multiple people recording this so that if anybody tries to do anything, cute, it'll be recorded, and then then we can crack down and make the person pay $50 or $60 or something like that. But you often get this, no, that just wouldn't be appropriate kind of thing. And then when you actually, if you challenge it, which a lot of attorneys won't, you're just kind of told that the emperor has clothes. They can't tell you why.
Yeah.
So pushing back a little bit, I think, and Duane, I think you would agree on this. I don't know you, but just from hearing you, I would think you'd say, it's good to, I do agree. You want to show that you can be trusted. You want to show that the allegations against you are false. So you want to act in good faith. And I tell clients, stay frosty, stay classy. But also don't be afraid to speak up and say, wait a minute, he's naked. Why are you making me do all these things when there's no need for it? And even if the court isn't really receptive to you, you can't help but plant those seeds where eventually the court will come around and say, yeah, look, why am I making him or her do this? Why am I making these expenses be incurred? Why am I doing these things? They don't seem to be protecting the child at all. They don't seem to be doing any good, and they just waste time, money, and effort. So,
no, I agree with you. I just want to dovetail with that and just say, I think a lot of times when people are in court, I mean, and maybe this is the direction, Eric, you were going. So basically I guess this will be a question/advice comment, would be, you need to recognize if you get caught up in that you need your attorney to say, hey, wait a minute, and not just say, yeah, okay, we agree to supervised visitation, clickety click, clackety clack, and then the hammer's down and done. You need to push back as much as you can. I mean, now obviously, like Eric, if you were my attorney in this situation, and if you're like, hey, brother, this situation, you kind of stepped into it, I'll ask to say that this is unreasonable, but this judge leans towards this and you're probably going to get stuck with it. I would imagine sometimes that's the conversation you have, and maybe other times you're like, hey, you're able to push back on it. Are you?
This kind of gives me
I think you're muted.
Oh, it looks like he's trying to talk, but he's muted. Go ahead.
Yeah, sorry about that. First of all, I'm going to say this. I'm a lawyer, but I don't like lawyers generally. And so the first thing I'm going to say is that if you think that this is going to be with Wendy and I saying, make sure you tell your lawyer this or get your lawyer. I mean, sometimes a lawyer is necessary. Sometimes without a lawyer, you're just going into the lion's den. You really are. Sometimes without a lawyer, your so-called common sense is going to lead you in the exact opposite direction you want to go. But I will tell you that whether you have a lawyer or not, it is important to have a reality check. It is important to make sure you understand how the system works, because we all have blind spots. And so if you're that parent being confronted with the possibility of supervision, you're going to be like, this is ridiculous. This is a conspiracy. Everybody's against me. This is so unfair. And much of that may be true, but some of it may not be untrue. Maybe you do have some concerns, some things that you've done that have raised concerns that really aren't problems, but you've got to cure that. And then other times you just can't see what's really going on. But whatever happens, make sure that you talk to an attorney, or at least somebody like Duane who's been through it, so that you can find out what you are about to enter, what you're about to experience. Because if you think you know what will be happening in the legal system, you are sorely mistaken. It's a different world. It really, really, really is.
If I can I jump in for a moment? Because I want to. So one of the things that I'll say that really got under my skin is not understanding the process. And like you, Eric, you just said, walking in and thinking, okay, here's the rules. I think I understand the rules. And I swear to God, for the first year, it seemed like every time something happened, it was like if you turn the page, there was a picture of me and it said the rules count unless you're this guy. But what I mean is, it's like I didn't understand. I thought you go to court that one day and it's over. And it took my attorney to say, no, that's just the initial hearing. And then we're going to have a status hearing, and then we'll have a discovery hearing. And I'm like, holy hell. You mean I got 3 or 4 or 5 more court dates before we get to the point, which we ultimately settled. But I mean, that was just like, oh my God. And then it was like, oh, by the way, you're going to have to pay for her attorney. Oh, by the way, you're going to have to pay for the custody evaluation. Oh, by the way, they're asking for information that they already have, but now you have to jump through flaming hoops, and you better get it quickly, even though they already have the information, because they're asking, you know what I mean? It was just like Eric, you just said, if you walk in and you think, I mean, unless you watch a ton of all your guys' channels, right? I mean, if you educate yourself, maybe you can figure this out. But if you walk into court thinking that you got this figured out and it's going to be fair and it's going to be just, and you don't have an idea what you're dealing with, you will get crucified.
And Duane, to those who say, well, those who are listening or watching saying, well, he's just a crank who had a bad experience, what would you say to them? What would Wendy say as well? What would you say? Because people need to realize Duane is not a crank. Duane is a normal human being.
This is what I would say. Okay, this is what I would tell you. If you're sitting here listening to this and you're thinking, but my beautiful butterfly would never do these things. We just fell out of love and it's not a big deal. And they said that we're going to have an amicable decision. Oh, okay, but protect yourself. I don't know how many people, and I'll say men, because in this situation, I mean, this has probably happened to women too, but I've heard this a lot, and I've seen it with men, is they believe it. They walk into court, and then it's like restraining order. They're abusive. They're physically abusive. They've taken all the money, and they walk out like, what the hell just happened? You know, I mean, so if you think that what I'm saying is BS, like Eric said, consult with an attorney. You can consult with an attorney and still file pro se. I mean, actually, I did that. I didn't want to go down this pit of hell. So I got an attorney. I talked to them. They helped me file the paperwork, but I wasn't quote unquote represented. I mean, I had paid them a retainer. They were my attorney. But when I filed my case, I did it pro se because I figured, well, there's no reason to throw gasoline on the fire. So technically, Eric, I was one of those people. I started this thinking, we've been married 22 years. This isn't, I mean, I don't drink. I've no domestic violence. I work for the federal government. No criminal record. I have a security clearance, which means I have to have a squeaky clean background or I lose my career. I figured this is a no-brainer. And then the next thing I'm looking at abuse allegations, potential rape allegations, I mean, and thank God my ex wasn't smart enough to go the supervised visitation route and all those different things. I think mainly it's because she was lazy, and I was taking the kids back and forth to school, and she didn't want to stop that. But I mean, it was just short of that, and it freaking blew my mind. Anyways, I don't want to monopolize it.
We have
definitely
about
want to hear what Wendy
16
says.
minutes, and you can go into that too, Wendy. But one of the things that you said prior that was important, Wendy, do you want to take this topic, or do you want me to bring up what you brought before?
Oh, yeah.
Because there was something you mentioned that I think is being overlooked. You talked about the other side of the coin, which is that it's supposed to backfire because under the best interest factors, there's this whole, if you are not going to facilitate contact, then you could lose custody of your children. A long time ago, when I was litigating, it didn't seem like the judges cared about that. Now it seems like they care more. So whatever you wanted to respond to with Duane, I hope you can touch on that, because that is the other side of the coin, and it's very important.
So, so anybody, anywhere who's watching this should know that the judge or the court is going to be looking at what is in the best interest of the children. And depending on where you are, there are certain factors the court looks at. So two of the courts, for example, that I focus on quite a bit are which parent is the parent that's more willing to allow frequent, meaningful, and continuing contact with the other parent. So say in one of my cases, the other parent has obtained a false order of protection against my client, and that order of protection was upheld because my client went to a hearing and didn't know what they were doing and represented themselves. But when everything comes out in the wash, it comes to light that this order of protection really wasn't warranted. Well, then I could use that particular best interest factor that I just mentioned to it's a piece in the puzzle that the court needs to look at in making a decision about decision making and parenting time. Another factor that I choose to focus on quite a bit is whether a parent has made false allegations for purposes of gaining an advantage in the litigation. So again, like using tools like order of protection when they're not warranted. You can use that. Making false domestic violence claims or making false allegations of drug use, and then they don't prove up in the end. Those are things that people can use to support their cases, to show the court that this other parent, they're not being honest, they're not being forthright, they're trying to play around the rules, not play by the rules, and if they're not following the rules when the microscope is on them, then they're not going to follow the rules when court is over and everybody's moved on until the next court litigation starts.
Is that argument becoming more effective, Wendy? In Nevada, it's a little bit more. How about for you in Utah? Does it work? Does it actually cause a custody modification?
Yeah, absolutely. Because I agree. What's interesting? I was going to say my mic is on, but I don't know what to say about that. I don't know.
It feels like it's weak in Nevada. They do consider it. It's more important than it used to be. But I don't see a whole lot of people saying, hey, I proved the false allegations and I got custody of my child. Usually there's 10 times worse things going on. I don't know. Go ahead, Wendy.
I think that... Oh, sorry. I just want to add that it's, I feel like there's never a smoking gun. People come in, they're like, oh, I got this on my ex and I'm going to win the case. No, this is a puzzle and there are little pieces and you have to put the pieces together. So just one of the things that I mentioned isn't going to do it. There's usually a lot of other things going on. And yes, you do have to prove them up. So, people don't say my kid wants to live with me and think that's going to win you the case, because it's not. There's a lot more there.
That was the best quote of the video, because I get those emails all the time.
I just want to add in on that, is that, with what Wendy was talking about with, coming in with the quote unquote smoking gun, I think a lot of times people come in with these things that are really minor and it hurts their credibility. They're coming in and they're saying, I had somebody who had asked a question like, well, how much do you have to document that someone's, not showing up on time and trying to interfere with visitation? I'm about, okay, within 3 months, 4 or 5 times or 5 to 10 minutes late, if you're going to go back to court for that, you're making a bad call. Let me put it that way. you better have some really hard hitting stuff that you're basically trying to file contempt charges for, or, ask for contempt, because it's life, right? Stuff happens. Sometimes you're running late. Sometimes little Johnny forgets his shoes, and you don't want to get into a situation to where you're freaking out just so that you're not 1 minute late. But I know that there's people who are like, I'm going to call the cops. They use it as a threat, and they're not necessarily going to go back to court, but they'll say, well, you're 10 minutes late. Where are you? You violated the court order. I'm calling the police, or calling CPS, or whatever. You really have to choose your battles, or pick your battles. I talk about that a lot, and actually, later I want to ask you guys a question about that, but I'll back off for now.
I'd like to chime in on the idea of, if you can prove that the allegations against you were false, could that be a basis for a change of custody? Well, what's interesting is that it does happen sometimes, but it's almost as though that's not really the reason there was the change. It was, well, as long as the kids will benefit from the change, then that's what we'll do. So, all right, you got caught lying, and it's not going to hurt the kids to change custody. All of us, all lawyers and pro se litigants are going to tell you they've either witnessed firsthand themselves or seen it, where the court will say, all right, I caught the other parent lying or absconding with the kids or in just gross alienation efforts. However, changing custody might be worse than leaving them with the alienating, lying, cheating ex-spouse or parent. And so it's really annoying, because the courts will set up temporary orders on the flimsiest of charges, on just a bunch, just allegations. This, as they used to say, the seriousness of the allegations, as opposed to the substance of the evidence. And then you get these temporary orders, so-called temporary, that have lasted for a year and a half, if not years. And then you go and you say, all right, look, I finally proved it was all a house of cards. It was all lies. It was doing all sorts of damage to all kinds of innocent people, including the children, but certainly not limited to the children. And then the court goes, yes, but I'd sure hate to make a change. The kids are accustomed to being in this dysfunctional, crazy situation, and I would sure hate to change that for them. When you're going, well, what about if the parent died? What about if the parent went blind? What if other things happened? That would be an upheaval in the children's lives, but they would get over it, and ultimately things would be better than leaving them with the dead parent, leaving them in the care of the blind parent who can't even take care of him or herself. There's just a lot of things that go on here where I think what it really comes down to is a lack of courage and a failure to understand that life consists of liberty and freedom and agency. And we're never going to be able, with the stroke of judicial pens, protect children from life. But that's exactly what they try to do, because they don't want it on their conscience that they made a mistake.
Yeah.
Well, we're almost out of time, guys. I guess, well, unless, I was having fun, but there's 4 people. I don't want to just take everyone's time up. Were you thinking 1 hour, Wendy and John and Eric and Duane, or were you guys thinking longer? Everyone loves it. They're commenting. They're happy.
That's good.
No, I didn't even ask you how long it was going to be, so I didn't know.
Well,
but
no complaints from my viewers.
Can I ask a question?
Ask, yeah.
Well, can I bring up a topic real quick? And it's basically, it'll go for all 3 of you guys. So one of the things that I've not struggled with, but one of the things that I've had to come to terms with, and we kind of talked a little bit about it, is like picking your battles. When is it appropriate to go back? And like, for instance, in my situation, I'm 9 years into this divorce. I think maybe the separation is 9. I get confused on the time. Right around 9 years for the divorce being final. And so now I got 1 kid left. If I go into the California guideline calculator, if I was to go back and ask for a modification according to the calculator, the numbers would go down. And I haven't done that, because there's always second and tertiary costs to this, emotional costs to the kids. What do you guys recommend on when is it an appropriate time, if ever, to go back to court? Like in that scenario, like because a lot of people are really angry about the child support, and if they could turn around and lower it by, in my situation, it'd probably be $400 to $600 a month, that it would go down potentially. Now, I mean, it's always up to, God only knows what would really happen. But for me, I'm just like, it's really not worth the cost. So I'm not doing it. But there are people, I know if that scenario would have been in effect for me 7 years ago, I would have burnt the damn house down if I could have got 5 cents back from her just out of anger and frustration. Wendy, what's your advice on that scenario and when you decide, or when is it an appropriate time to go back?
Well, in Arizona, when it comes to both child support and decision-making and parenting time, a court is going to look at whether there has been a substantial and continuing change in circumstances. So as far as child support is concerned, a substantial and continuing change in circumstances means a 15% increase or decrease from the current child support amount. So a person is justified in going back if they can show. So I've had cases against people who file a modification because they changed jobs or something changed. And then it turns out that the new child support number is not a 15% modification from the current amount. So guess what? After thousands of dollars, that child support amount remains the same. So I always tell people before going to court on child support, do some worksheets, do some projections and see if you're going to get a change. As far as modification to decision-making and parenting time, it takes a lot. I feel like it's not an insignificant amount of evidence that needs to be presented to get a change, and time alone will not get you that change. I don't care if it's been 5 years since that decree was entered. What have the changes been besides the fact that the kids are older? Has somebody gotten married? Has somebody had a baby? Has somebody moved across town? What are those changes? And that's what you have to focus on. And then, Duane, you kind of alluded to this, people have to think about how much money they're going to invest and weigh that against how much they had to gain in the long run. If they have a year of child support left and they're going to spend $15,000 getting that changed, is it worth it? I don't think so. Probably not. So you got to do that cost benefit analysis. And I always encourage my clients to do it.
Go ahead, Eric.
I'd say that if you're going to get, for every dollar you put in, a savings of at least $3 or more, do it. Otherwise, you're just going to end up spending the same amount of money you were going to get stuck with. And that is hard. Those are hard words to hear when it's like, wait a minute. So I shouldn't have to pay anything because the law says I'm entitled to a modification, but I've got to spend so much money to do it. And if I win, won't the court award me my fees? Not bloody likely in my experience. So even if you win, you're not likely to get them back. So what you really have to say is, if I've got $15,000 left to pay in child support, it's probably not worth going to court because I'll have to pay at least $15,000 to save $15,000, meaning that I spent the same amount of money anyway.
Yeah.
The tough part about that is, and I've seen this with people, and there was a time where I would have probably been that person, that if it was like, okay, I can give them the $15,000, or I can spend it so they get nothing. People get caught up in that, and people, what they have to look at is the emotional cost of themselves, right? Because here's the other thing is, Eric, I don't just come to you and I say, hey, you know what? My life is going pretty good and I want a modification. So I'm going to give you 50 grand to go try to screw with the ex to see if you can lower the number. I mean, not that it would be great if that worked, but that's not the way it works. What ends up happening is you get thrown right back in the middle of the garbage. You get basically going back through a whole nother, like going through another divorce. And there's a cost on the other end for your sanity that I don't think a lot of people think of, and consider. And that's been the reason why. I remember a couple of years ago, I was talking to Child Support Services in California, and it was when my second child was getting ready. I have 3 kids, was getting ready to drop off, and they're like, well, she needs to get a job because California has switched to go get a job. They will impute wages on a mom who's not working, and it doesn't matter if they're going to college. They don't care. It's like, get a job is what they said. And I think Alex even looked at the statutes, and he was like, holy crap, they changed it. I never did it because I was like, what is the cost? And there was one time where I made a comment. I was irritated with the thing that one of my ex was doing to one of my kids. And I made a comment about it. And the blowback to the kids was like, oh my God, it wasn't worth it. You know, I mean, it's like, I think people really need to think about that. But it's hard to get to that point to where you can, I mean, I hate to say let it go, but to where you get to the point where you say, you know what, it's not worth it. You know, that person is dragging me down into the pit of hell, and it's not worth my sanity and the effect of the kids. And yeah, they're getting away with more than they should. You know, they're abusing.
That's a very good comparison.
You know,
yeah.
That's a very good comparison. There's a difference between just let it go and it's not worth it. Letting it go means I'm going to be the bigger man. Letting it go means it's that the pain that I have to go through isn't worth the payoff. But it's not worth it is, why would you spend $15,000 to save $15,000?
Yeah.
All you're getting is to zero, and then that doesn't count, as Duane points out very well. That doesn't include the time, the effort, and the emotional toll it's going to take, not only on yourself, but on your kids potentially as well. And look, and I'm a lawyer. I get paid whether I win or lose. Right. But I would be remiss if I told somebody, I'll do my best, when I know that the odds aren't that good. So that's why I say, if you're not going to save or get $3 for every dollar you put in, it's probably just not worth the money and the effort you put in.
Yeah, I agree.
You know, this makes me want to ask both Wendy and also Eric as attorneys. I guess we'll start with Wendy, but have you had a case where backing off didn't solve the problem and the other parent just ramped things up? And so let's say the client, we'll say visitations, maybe they lost 4 visitations, and it's not worth it, let's just let it go. And that actually caused the other parent, or it just happened coincidentally, to just keep doing it. In other words, a small thing which didn't really lead to litigation didn't really end the issue. In fact, the issue continued. And what do you think about that kind of situation? We'll start with Wendy.
It does happen. And I have had it happen, not specifically with respect to the example that you just gave, but for example, say my client is prepared to concede an issue, and we think, the other person or the other party is going to be thrilled because we're conceding this issue, which may not be the biggest issue for my client. And then it turns into, we'll only concede the issue if you agree to pay the attorney's fees and costs for the party. And then so it turns into a big argument over attorney's fees, and then, it just doesn't resolve the issue that you think it's going to resolve. So yes, it does happen, Alex, and I forgot what the question was.
I mean, you kind of covered it. I mean, that was the answer, is sometimes letting it go, being the bigger person, doesn't actually end the issue. It just continues. Or it gets worse. And not always, sometimes. That's all I'm saying, Duane. Go ahead, Duane. Yeah.
Can I chime in on that? So no, what I would say, and this is what I tell people, your best bet is at the beginning. You need to hit your home run while you're in court, because that is a time where if you can get a big enough victory where your ex goes, oh crap, this is this could actually blow up in my face. That's your time. And I agree with you, Alex, that if you're the bigger person, and I had a conversation with a friend of mine in real life who's going through a divorce right now, and his ex is a train wreck. Probably I might be diagnosed with borderline. The mother-in-law and the brother-in-law are both willing to sign, to whatever you need, son-in-law, let us know so that you can have custody of the kid. And I was talking to him the other day, and I'm like, dude, if you have all that lined up right now, here's the deal. If you had full custody, because he's like, well, I just want 50-50. I just want 50-50. I'm like, I get it. If you had 100% custody, are you going to let your ex see the kid? Well, of course. And it kind of goes, Wendy, to what you were talking about. Who's the parent that's going to facilitate contact? It's like, you need to go for that and win the biggest victory you can at the beginning, because you're reasonable and you'll allow contact, and you won't use, the court order says you can only see them on these days, or, even if it's 50-50. I went through that. I mean, I went through where it's like, oh, there's a school function on her day. Well, you can't go. Like, what do you mean I can't go? well, it's my day. You know, I mean, that type of stupid stuff. So I know it kind of dovetails in with what you were saying, Alex, but I think that if there is any chance that you can land a good hit so that the person realizes, oh, okay, I need to back off, you're better off. Because if you just let them have everything and then they get full control or majority control within court, and then they feel that they can use the court as their the extension of their arm to inflict damage and control, I think that's a nightmare.
What do you got, Eric?
I do agree with Duane that you want to play your strongest cards right up front when the court is most willing to listen, when the attention spans are longest, and when your credibility is as shredded as little as possible by all the false allegations up front. I would also say that it would be wise to document, all right, I was supposed to pick up the kids this weekend and you prevented that from happening. Do not mistake the fact that I didn't call the police and didn't make a scene with weakness, because I don't want the kids to be embarrassed or upset or traumatized. So remember, I'm not happy about this. Don't let this happen again. And then usually you have to have 2 or 3 of those before the court will treat you as somebody who's not coming into court and wasting the court's time. And I can see some truth to that, saying, well, do we have enough dots connected to show that this is a pattern or practice of contempt or contemptuous behavior? But then what you do is you come in and almost demand relief, saying, look, this didn't happen and it wasn't my fault. And I didn't make a big deal out of it because I didn't want to involve the courts, Your Honor. So I hope that by showing that I was being magnanimous, that this would prevent this from happening again. Instead, it seemed to create an appetite for more contempt and alienation. So it happened again. And then I said, all right, you do this again, and I'm taking you to court, Your Honor. And I meant what I said, and I did exactly that. And now I'm here. And I've done this before. Now, again, you're talking to the iconoclast. I said, I've done this. Your Honor, if you don't give my client relief, mother or father, what am I supposed to tell her, him, and everybody else in this client's position in the future if you don't do something now and put some teeth in your order? Because otherwise, what am I supposed to tell my client? Oh, you know what? It doesn't matter if you're patient. It doesn't matter if you've got them 6 ways from Sunday. This court doesn't have the guts to punish someone. And Wendy, with all due respect to the women, a lot of times it's like, because this is a mom. I don't want to put a mom in jail or something like that. And I go, Your Honor, I understand that. And I think that's laudable that you have those feelings, but if you're going to let somebody abuse the system like this, then your orders are worthless, the rule of law is pointless, and you're really telling people to take the law into their own hands, because it certainly didn't do us any good to come here today. And unfortunately, it's getting to the point where you really have to get that hyperbolic sometimes for the court to take you seriously. Now, again, you can't come in like a bull in a china shop the first time, but go ahead and let yourself get smacked around by the court and make sure you document it. And then when you come in a second time, you know what I mean? Yeah, you say, look, I tried doing it your way, Your Honor, which was basically kind of bow your head and go away and make my job easy. And I did make your job easy, but at my and my kids' expense. Yeah. I ain't doing that a second time.
End of filings is not end of abuse. It's what I always struggle to get my judges to understand. They always seem to want us to just work things out and go away. And they just had it in their head that once the filing stopped, everything must have been fine after that. Or maybe they just didn't care. I like to think it's just that they connect the filings with issues and the end of filings with the end of issues, which isn't always true.
Right.
So
go ahead.
I want to, Eric, when you did,
go ahead.
I want to say, when you did that, did it work? I mean, did the judge say, okay, I'm going to give you the relief, or not?
The judge, now again, I'm being a little dramatic, but the point I was trying to get across was, if you won't put teeth in your orders, if you're going to allow the opposing side to keep flouting the law and your orders and just rubbing my client's nose in it, what am I supposed to tell my client when this happens again? Because I'm certainly not going to tell them, yeah, come back to court and get the relief to which you're entitled, because he's already done that 3 previous times and he's been shown the door. And so, Your Honor, what am I supposed to tell him? Because I, as an officer of the court, certainly can't tell him, yes, trust the court.
Yeah. Well, and on top of that, 3 times, I mean, you're talking at least probably, $3,000 or $4,000 just in showing up at court, and then all the prepper. I mean, probably more than that would be my guess.
That's what I'm saying. It's like, look at all the money, look at all the time, look at all the missed opportunities. That kid only goes to communion once, first communion once, things like that. These things have been lost. And if you're going to do this again and wag fingers and say you're both responsible, that's BS. You know what I mean? And stuff like that. You say, what am I supposed to tell my client? Because I'm not coming back. He certainly or she certainly won't be coming back here again because you keep failing him or her. And and the judge in this particular case understood, and to his credit said, you're right. I don't like putting moms in jail. I don't like imposing fines. I don't like penalizing people, but I certainly shouldn't be allowing them to get away with this. And if I do, even though the judge didn't say this, I think a lot of it was, no one's going to make a monkey out of me. No one's going to make a fool of me. No one's going to, I'm not going to be the impotent judge, which is good. I mean, use your power to enforce the law. That's what it's for.
I have a technical question for Wendy, and then Eric Johnson. This is, like I said, technical. How often do you use the peremptory challenge of judge, and is there any sort of thought process that you have behind it? We'll start with Wendy.
Well, in 2020, I didn't use it much because there was an administrative order entered by our Supreme Court that because of COVID, you couldn't use it. It was just causing too many issues. But before 2020, I really didn't use it that often. I do use it, if I've been in front of a judge and I feel like they made a decision that wasn't based on the facts that were presented or the evidence that was presented, and I just feel like they didn't give a good result. Or, I've heard, rumors about certain judges having personal issues, that's affecting their ability to do the job. So in that situation, I would use the strike. But the problem with it is that when you use it, because you think you don't have a great judge, you could end up with somebody worse, So like everything, you have to evaluate the risk. And, if I make this in this particular part of the Phoenix metro area, what other judges am I likely to get? And if there's another judge that's worse, then I may stick with the known quantity.
I wonder what Eric has. And I'm not sure it's allowed.
I have never used it. I am afraid to use it. I think it's one thing to disqualify a judge for obvious bias or prejudice, but I would always be afraid to get a reputation. And I think all you have to do is exercise the challenge once. We don't have. I'm not exactly sure what you're referring to, because we may be talking about slightly different rules.
Some states don't have it, so it might be that Utah doesn't have it. It's a
Utah's rule. Yeah, Utah's rule is that if all the parties agree, they can demand a change of judge by right. But otherwise, you don't have any kind of peremptory challenge. And if I ever did, I'm afraid that I'd be known as the guy who gets rid of judges he doesn't like, who then would create a bunch of judges.
They use them
that don't
all
like
the time
him.
here. It's so common. They even put them in the papers, like they do statistics on which judge gets. I don't know if they do that in Arizona. I don't know if it's that big. So
I don't know, but I think it happens fairly often, and I've never been concerned that I'm going to get a reputation. I think I do a good job, and judges know
it's
that,
different in Utah. I've heard other Utah attorneys. It seems different there. It seems just, I don't know, but here it's like what you described, where they don't seem to take it personally. It even goes in the papers and stuff. And I think
that's the way it is here too. I know whenever we were way back when I was talking to my attorney about it, they're going in strategy that they would probably disqualify the first judge just to get the second one. Now, the one thing I just want to add to everyone, and Wendy and Eric, you guys didn't mention it, but I think one thing that people forget with getting local attorneys is you guys know the judges. So you've dealt with them, you dealt with the other attorneys, you know what people are what they're like, what they expect, what attitudes will work, what arguments will or won't work. And I think and unless you're going to go pro se and you're going to spend a significant amount of time sitting in a courtroom watching what things happen, it's important to have a local person on your team in your camp who understands the court system that you're going to be engaged in. Which also, just a caveat for people is, I personally think, and I did this starting out, do not hire an attorney who is outside the area. Yes, they can practice law in that area, but they do not have personal relationships with any of the attorneys in that area, and they don't know any of the judges. I mean, so you're going to spend money either way. Spend money on somebody who understands the environment you're going to be in. What do you guys think about that anyways?
I agree 100%. And in my office, we call people who don't practice family law, maybe they do criminal law and then they're like dipping their toe into the family law pond. We call them dabblers, because there are certain things that they don't know, they're not aware of, how to conduct hearings, how much time each side gets during a hearing. And really, I've seen them really screw their clients over, So by spending the whole hour cross-examining my client and not realizing that they don't have any time to then call their client for their case in chief. So don't get a dabbler, get somebody who knows their family law stuff. I think that's a good practice tip for people, Duane. And also, yes, somebody who knows the local judges, the local bench is definitely helpful. So I agree with that.
I would say that if you're trying to save money, and attorneys are very expensive and likely getting more expensive before they get less expensive because of some of the changes technology has brought, I think the thing to do is, if I were going to build a commercial building, okay, which I have no background in at all. I have no background in construction. So let's assume that I got a lot of money from some windfall, so I decided to invest in real estate and build a building. The last thing I would do is try to work with the code office and the inspectors and the licenses and all that kind of stuff, and do it all on my own, simply because I don't know the unwritten rules. I don't know, that so-and-so expects you to do this when he shows up for the inspection, and these people expect you to do this and do that. And I don't, I'm glad we don't live in a banana republic at this point. But, what if I found out, what if I lived in New York or something like that, where it's like, oh, by the way, this guy, he expects you to slip him a little money to do this or do that, or your license will go unpaid, unissued for months or something like that. The same thing applies with a lawyer. If you want to go pro se, Duane is absolutely right. Consume tens or hundreds of hours of courtroom time, because you simply, guys, gals, you just do not know what's going to happen. It's a different world. You've watched a lot of Law and Order, and that's very nice, but it's not enough. And I'm not saying that to sound condescending or patronizing. And then secondly, talk to lawyers. There are lawyers out there. I'm sure, well, I'm one of them, and I would guess that Wendy is one of them too. I don't want to speak on her behalf, but if you say, look, I want to do this on my own, but I want to pay for an hour or two of your time to get a feel for what I'm supposed to do, what's my format of my pleadings, too long, too short, what kind of fonts, what kind of stories should I tell, what should I not, things like that. Hey, could you help me with my research here? Or I was told I had 6 days to get this done. We love it when we get hired on a regular basis, but even if I can see somebody is hard up for money, but doesn't want to lose and realizes, like Duane said from the beginning, I've got one shot here. Do not jump over dollars to pick up dimes. But both of us, there's two lawyers here. Both of us have said, you don't have to hire us. We're not going to hold you over a barrel. You may need to hire us, or you're going to just be jumping over dollars to pick up dimes. But please talk to lawyers, talk to 5 or 6 or 7 of us, and find out what you need to do, even if it's just for an hour or two. Because if you go in there by yourself and just think, well, the truth will set me free, you're a fool.
Tenacious Warrior wants both you and Wendy, to ask me a specific question in line with what you just said, as to specific facts as to what helped me as a pro se litigant. Because I don't think Duane represented himself, so I'm assuming she means me.
No, I had an attorney.
So I guess she's asking for you guys to ask me a question that requires me to disclose some facts on what helped me as a pro se litigant.
So I think I know Tenacious Warrior well, and she's been doing a fantastic job of representing herself. You know, and I know one question she's had for a while, and I don't know if she's gotten the answer, but you know, she asked for a hearing on an issue a while ago in the court. It was like in January, and she hasn't gotten a hearing. So if anybody like Alex or Eric has suggestions on how she can get that hearing when a judge is just ignoring her request, that would be great. But the second thing is since like January.
I have an answer. Go ahead though.
And then, but the other thing, Alex, if you can provide like concrete, actionable tips, like maybe 3 of them for the pro se. No, you can't do it.
I could do it.
Oh, I don't know.
I could try. Yeah.
Yeah. You know, for the pro se as they go into their case, that would be great.
So the first one was what would I do if I filed a motion I didn't get a response? So to be honest, if I waited 2 months and I didn't get a response, that's normal. It happened all the time for me. So it would have to be longer. I know exactly what I would do. As soon as I would say 5 months, 6 months passed, I would file a motion or a petition for writ of mandamus in the Supreme Court. And I would there's a Supreme Court rule that says the judge has to bring the matter to a resolution within 6 months. Most likely, they would just scold her. I've seen these orders come down where they decline to consider the writ, but then they state something like, we think the judge, we have their attention and they'll take care of this, you know, in a timely manner. If they don't, I'd file another petition for writ of mandamus, and then the second time it usually works, and they'll issue the writ. There's a rule in Nevada that says they have 6 months. They need to show why they can't comply with that. And they do mention in unpublished decisions that there may be reasons for why it's taking them longer than 6 months. They kind of allude to you're not just automatically going to get hit with the writ of mandamus. But that's what I would do. Hope that answers your question. It's just based on my knowledge of the only way you can get relief is by a writ and without a ruling being entered. You know, with no ruling entered, there's nothing to appeal. So you can only twist their arm with mandamus. The 3 tips, I have a lot of tips, but I want to think of the best 3. The first one is that no matter what you think with regards to how fair something is or how unfair something is, you're going to win or lose depending on statutes, rules, and case law. So if you're going to try and do something like modify child support or change visitation or something, you can't just think, here's the reasons why I should get what I want. That's not going to work. You have to go in, and you can't even come in with like Google or even Wendy's channel, you know, pursuant to Wendy Hernandez's YouTube channel. That doesn't work. You have to use pursuant to and then cite the statute, the rule, or something like that. The other thing I would say that's important is to not let, so a lot of people know that when you lose, sometimes you just take a crushing blow and you just don't want to go back to court. I've seen issues on the other side of that where people are winning and they kind of get drunk with victory and then they start to go too far. So as a pro se litigant, you're not going to have to worry about the other one. You're going to lose something and you're going to just quit, walk away, fine. It's sad, you've given up, but you can fall into all sorts of trouble with the other scenario that I described where you win and then you start to get a little too crazy and ask for things that are way out of bounds, and now you're getting sanctioned with attorney fees and you've lost all your credibility, which is very hard to get as a pro se litigant because they just assume you're garbage automatically until you start to really show them you're different from the others.
Well, that's what happened with you, right, Alex?
It took forever for them. It took appeals for them to finally treat me differently. And when you're not getting treated differently, you're just on the conveyor belt. That thing is going in one direction. So usually it's denial or dismissal. And sometimes when you're lucky, and this is me joking, you'll get hit with attorney fees on top of all that. So I don't know about the third one. Those are my 2 biggest ones. Statutes, rules, and case law. And go ahead.
I think those are good tips, Alex. You know, people, the person with the most paper wins, document. That's what I think. Present your evidence, get your evidence ready. And also, you know, there is something to be said for getting a great victory right at the beginning. But the fact is, that doesn't happen a lot of the time. And for the people who have been dealt a really hard blow at the beginning, don't give up hope. I want to say that I've had many clients, you know, had been ordered to supervise visits, for example, or ordered to drug testing and falsely, and they turn things around. So there is hope. Even if you don't get that big victory up front, don't give up. Like I say, you got to keep on trucking.
That's a good one. Yeah.
That's my 2 cents. Yeah.
And if I could give my 3, I would say, now every jurisdiction's a little different, And so in my jurisdiction, if you don't get a decision within 60 days from the day it's submitted, then it's like what Alex was saying, is that you could bring it to the attention of the presiding judge. We have a presiding judge. So your judge is one of the judges in the district, and then there's a presiding judge over those judges, and that changes from every 6 months or so. But so you could say, presiding judge, I just wanted to bring to your attention that it's been more than 60 days and I haven't gotten a decision. And before I did that, I would email the clerk and say, hey, I just, it's 61 days, didn't want to be a pest or anything, but just, I happen to know that there should be a decision by now. Maybe you've issued it and I didn't see it, so I'm just asking. And then if that doesn't, if they say, well, we'll get it to you in a week, then that's nice. And if not, then you go to the presiding judge. And then, of course, if that doesn't work, it's like Alex says, you would go to the appellate courts and try to get a writ of mandamus. Another thing I would do is, again, I would second what he says about knowing the rules, citing the rules, statutes, and case law, because although that's not going to always win, I'm a little more cynical about things. I've seen courts that just say, oh, I know the rules. They don't come out and say it, but there's like, I know the rules, but I don't like them. I know the statutes, I don't like them. So I'm going to disregard them, or I'm going to disregard the facts that don't let me get to where I want to go, or I'm going to fabricate facts that let me get to where I want to go. Either way, and that does happen, I'm afraid to say. And then third, what I'd say is make sure that you're very deferential in court, but don't be anybody's fool. So, just be very quiet and deferential. But when you want to object, you get up and make an objection. And if the court says you can't make any more objections, you just kindly say, well, I'll be doing this for the record. It's like, or you can't do this, you can't do that. If you've got a rule, say, oh, I'm sorry, I read the rule to mean this. And if the court says, well, I read it differently, now you've made your record. So I guess my third thing, even though it's a different thing from Alex's, would be make sure you've made a very, very, very good record, so that if you have to take this up on appeal, the appellate courts will say, well, yeah, we don't like to turn on one of our own, but man, this pro se litigant really, this judge really gave this guy the business, and this litigant made such a good record. It's better for us to throw the judge under the bus than the pro se litigant.
It's funny. That's another important one for Tenacious Warrior, is making a record. Sometimes pro se litigants won't ask for something because they think they won't get it. Well, sometimes you not getting it wasn't appropriate in the first place, and you have to preserve that. Go ahead, Wendy.
Oh, no, I think those are all great tips. Make your record. Don't be afraid. I think you can be strong and courageous and assertive without being disrespectful. You can disagree with the judge without being disrespectful. I think judges know that. They expect that. If a judge gets offended about that, then it's more of a problem with the judge than it is with you. The judges are the refs, and they expect resistance. So, I think people, they got to stand up for what they believe in, but don't, stand up for something that's unreasonable, that's not supported by the law.
Was it fun, guys?
Yes, it was fun. So thanks,
Let's do a round of goodbyes. Start with Duane.
Hey, this was awesome. Thanks, you guys. It was nice to finally, Wendy, I think this is the first collaboration we've actually done. I think I've had you on my channel with videos before, but I don't think we've actually done this. And Eric, awesome to meet you and to get an opportunity to do this with you. And Alex, man, I always enjoy our collaborations. So thanks for having me. I appreciate it.
It's always great when you have a group of people to discuss these things, because when you're dealing with people that can watch all over the country or even parts of the world, there's a lot of things that overlap, but there's a lot of things that are different. And I hope you've seen that today. There are some unifying principles here, but make sure you know what's going on in your specific jurisdiction. Don't ever say that I watched Command the Courtroom and therefore that's why I win. Not because Wendy didn't have good advice, but simply because it may not apply. And the same thing with me. We've seen that there are different things there, but I would just say thank you very much. I appreciate the people that tune in and ask the questions, and I can't wait to do it again.
And guys, Eric is the new one here. He needs subscribers. Make sure you go check out his channel, subscribe. And Eric, you were on 3 channels today, 2 of which are both bigger than mine. So hopefully you get some of those subscribers from our side. Go ahead, Wendy.
Oh, well, thanks, guys. It was great to be here and hear some different perspectives. And, that's the thing with my clients when I'm working with them. I play devil's advocate quite a bit. they don't love hearing it sometimes, but it's part of the preparation. So if you listen to this and you heard some things that maybe rubbed you the wrong way, maybe those are the things that you need to look at more closely and examine. Am I doing this in my case? And if so, do I need to try a different strategy?
Here, here.
Thanks, guys. I mean, whether you're a guy or a gal, so, thanks, guys. Fun. Thanks for the invite,
You're welcome.
Alex.